Good morning and welcome to the Supreme Court of the United Kingdom. Today is the second day in an appeal hearing in the case of Kabab-Ji SAL and the Kout Food Group Limited concerning questions relating to international arbitration. We are present hearing the submissions of Mr. Nicholas Shea on behalf of the appellants. Mr. Shea.
My Lord, I'm grateful. My Lords, just before I go on to deal with issues 2 and 3, I wish to take you briefly back to the bundle at page 1954 and the section of Russell, which we considered yesterday, and to consider two more authorities on the point concerning the English common law requirement that an arbitration agreement be governed by a national system of law. Now, my Lords, if one considers the passage at Russell 2119 in its entirety, we say it's clear that the section is actually discussing and recognizing the fact that the convention test may be somewhat different to the common law test to determine the law applicable to an arbitration agreement. We say the section is not saying that the English common law rule that an arbitration agreement must be governed by a national system of law does not apply when considering a convention case. We say it does apply, and I wish to go briefly to authorities which demonstrate that. Now, in that section,
Mr. Chair, sorry, can I just check? Do we have all the footnotes? I mean, there's a large number of footnotes in this passage. Do we have those?
We do, and I'm just going to take you to them, my Lord, now.
All right.
Page 1957 of the appeal bundle. There's footnote 584, which is the footnote referenced in the sentence concerning national law. Footnote 584 is mentioned at the end of that sentence in 2119, and then one finds the footnote at 1957. Now that refers, my Lords, to the case of Masawi, which was a first instance case. And that was where at appeal bundle page 2208 and paragraph 81 of that case, the rule was stated. I'm going to read out paragraph 81. Although the Rome Convention incorporated into English law by the Contracts Applicable Law Act 1990 does not apply to arbitration agreements, the common law requires, in my view, the applicable law to be the law of a country for the reasons which I've already given. In the case of this arbitration agreement, there is no country other than England whose law could arguably apply to it. Accordingly, issues concerning the arbitration agreement itself are governed by English law. The reasons, my Lords, which were already given by the judge in Masawi are at paragraph 22 of that judgment, which is at appeal bundle page 2197. And that is where the judge relies upon both Dicey and Morris and also section 46 of the 1996 Act. Paragraph 22 says, Section 46(1)(b) of the Arbitration Act 1996 enables parties to choose principles other than the law of the country as the basis on which the dispute is to be decided by the arbitrators. Section 46 provides as follows. The arbitral tribunal shall decide the dispute in accordance with the law chosen by the parties as applicable to the substance of the dispute, or B, if the parties so agree, in accordance with such other considerations as are agreed by them or determined by the tribunal. 2. For this purpose, the choice of laws of a country shall be understood to refer to the substantive laws of that country and not its conflict of laws rules. 3. If or to the extent that there is no such choice or agreement, the tribunal shall apply the law determined by the conflict of laws rules which it considers applicable. The judge goes on, the law which may be chosen under section 46(1)(a) or which may be applied under section 46(3) must be the law of a country. See Dicey, Morris and Collins 14th edition, paragraph 16050 to 16055. And then I go to the bottom section in paragraph 22. The distinction made in section 46 between law being the law of the country and other considerations is consistent with what I consider to be the common law position. Now, my Lords, we therefore say that section 46(1)(a) of the Arbitration Act 1996 does reflect that rule, and we say that that makes sense because the law of the seat matters in international commercial arbitration. And having regard to the Article 5.1a and also, of course, Section 103.2b wording within the 1996 Act in this country concerning convention challenges, having regard to the wording, the law of the country where the award was made under Article 5.1a, we say that that is the default standard by which one measures the validity of an arbitration agreement for the purposes of the New York Convention. Now, my lords, if we can go to Dicey, please, now at paragraph 16019, it's bundle, page 1878. Now, in paragraph 16019 of Dicey, it is said the parties are free under section 46(1)b of the 1996 Act to choose a non-national system of law to govern the substance of their contract. The arbitration agreement, on the other hand, must be governed by a national legal system. And there's a reference to footnote 43, which I shall come to in a moment, my lords. Dicey continues, this may lead to a different applicable law for the arbitration agreement, even where the parties have made an express choice of law to govern the substantive contract. Now, my lords, in the appeal bundle, footnote 43 is truncated in the extract, but it cites the following cases. Halpin and Halpin, also stating that was applied in Massawi, which I've just taken you to, but it also cites the Dalla decision of this court. Now, Dicey clearly sees Dalla as confirming this principle concerning the fact that a national law must be the law applicable to the arbitration agreement. And of course, as we all know, Dalla is a convention case. Now, we've sought to try and puzzle out which paragraph it might be in Dalla which is relevant to that proposition. There's no clear paragraph, but what we see is this, that if, my lords, you go to page 1573 in the bundle and to E down the page, there appears to have been an argument put before the court by Toby Landau, QC, and Mr. Ingenieur, that the English court could not apply the French rules because they were transnational rules as opposed to being a national law. Now, that point was later abandoned by the respondent because it acknowledged that the French law principle still qualifies as principles which are a part of French law, even though French law regards them also as being part of the international legal order. And that's demonstrated at paragraph 15 of the Dalla decision at page 1577 in the appeal bundle. And the reason it was abandoned was because by that point, it had become common ground between the parties that it was a part of national law, that the laws which France, or the rules which France applies, did form a part of their national law. And so we say that the inference is that the English courts felt entitled to apply French law in Dalla because they considered that the Dallico principle to apply transnational rules was actually a part of French substantive law. So that concludes the authorities, my lords, which I wish to take you to in respect of that point. And now I will, if I may, move on to issue 2. My Lord Legate, I see you have a question.
Just before you do, both the
Yes.
Dicey and the case Massawi you showed us say that in contrast to deciding the law of the arbitration agreement, the parties can choose a non-national law for the arbitrators to apply, such as the unidroit principles. Isn't that exactly what's happened in this case? That the parties have chosen that the unidroit principles feature, at least as part of what the arbitrators apply to substantive dispute, but not to the validity of the arbitration clause itself.
Well, my lord, as we explained yesterday, our position is that because of the particular wording of this contract, that the parties chose in a non-hierarchical way to apply both English law and also using the words of second sentence at Article 14.3, page 378 of the bundle, they chose to also apply the union droit principles. And so pursuant to section 46(1)b, which my lord has just mentioned, yes, of course, the parties have a freedom of choice in terms of both governing law, whether it be a combination of a national law and or a set of international legal principles to apply as the either applicable or synonymous, we say, governing law of the contract.
Thank you very much.
My lords, should I, Lord Legate, should I move on? I'm grateful. My lords, I now come to issue 2, as defined by the panel, which is whether the Court of Appeal erred in applying the summary judgment test to a New York Convention claim, which should proceed by way of rehearing. Now, my lords, in addressing this issue, we'll offer first the appellant's submissions as to how an Article 51A challenge rehearing should be conducted, bearing in mind both this court's decision in Dalla, but also, of course, the prima facie validity and binding nature of a foreign award per Article 3 of the New York Convention, which we went to yesterday, and which is at bundle page 1295, because the language of Article 3 is very clear that each contracting state shall recognise arbitral awards as binding and enforce them in accordance with the rules of procedure of the territory where the award is relied upon under the conditions laid down in the following articles. Now, my lords, this court's decision in Dalla, we say, stands for the proposition that a rehearing is required if an award debtor raises an Article 51A challenge concerning the validity and or scope of the arbitration agreement, and that's per Lord Collins in Dalla at paragraph 104, that's at appeal bundle pages 1608 to 1609. But what we note in respect of Dalla, my lords, is that it did not provide specific guidance on how a rehearing should be conducted. Now, what we say is that having regard, on the one hand, to the Convention's objective of a uniform approach, as recognised by this court in Enker, paragraphs 125 to 130, that's bundle pages 1758 and 1759, and on the other hand, to the desirability of consistency in terms of procedural approach to such rehearings. We think it may be helpful if this court provides some guidance as to how Article 51A challenges, or even perhaps more widely, that's a matter for the panel, in respect of any convention challenge under Article 5, so Section 103 challenges under the 1996 Act, how those challenges should be heard. Now, the rationale for the guidance which we wish to suggest is this. In Dalla, at paragraph 96E to F, that's bundle 1606, and that's per Lord Collins, this court approved the decision in Azov shipping. And that stands, that decision, for the proposition that the court should not be in a worse position than the arbitrator for the purpose of determining the challenge where substantial issues of fact are involved. Now, we say that because of the nature of the challenge raised in this case, it's obvious that, of course, there are substantial issues of fact involved. Now, Robert Merkin and Louis Flannery, in their book on the 1996 Act, take the following view of the dangers which may be created if the Dalla guidance is left to be interpreted by judges on a case-by-case basis. And here I refer to the bundle at page 2698, and this is an excerpt from paragraph 103, subparagraph 7 of Mr. Merkin and Mr. Flannery's book. If the decision in Dalla is taken as authority for the proposition that in any case where a jurisdictional challenge under Section 103 is raised, even in circumstances where a party took part in the hearing before the tribunal, perhaps under protest, perhaps not, the court must automatically and necessarily discard the award, start the whole process again to determine whether the tribunal had jurisdiction, allow the defendant a full opportunity to re-argue the issues, and undertake a full re-examination of the facts. We question whether this is within the spirit or intent of the Convention. Such an approach goes against the whole notion of finality of awards. It would be a most regrettable principle, and in our view, a retrograde step, if this were to be adopted as a universal approach to questions of jurisdiction that arise on enforcement of awards. Now, my lords, what the appellant suggests is the following form of procedural guidance in order to, we say, both promote consistency of approach to convention cases, but also to a fair rehearing which gives effect to the contracting state's Article 3 obligations and ensures that all documentary evidence which was available to the arbitral tribunal is available to the rehearing judge. And thirdly, because there should be, we say, a streamlined procedure which is efficient and proportionate and therefore consonant with the overriding objective of the CPR. And so we propose a regime which we say would be fair but fast and efficient in terms of process, and which is based principally on documentary evidence. So the 5 points that we would put forward in advance as a proposition are that a rehearing, firstly, a rehearing should be limited to questions of law and fact concerning the specific points of challenge which are made under Article 5 of the New York Convention or Section 103 of the 96 Act. The 2, the rehearing should take the form of a fast-track trial, with the first CMC allowing at least 2 hours pre-reading for the judge in order that the foreign award at issue can be considered, especially the evidence upon which the arbitral tribunal based, for example, any findings as to jurisdiction, or which are relevant to the particular challenge which is raised. Thirdly, we would suggest that the judge giving case management directions should consider whether the challenge should be tried on the basis of only the documentary evidence which was before the arbitral tribunal. Fourthly, we would suggest that unless witness evidence was relied upon by the arbitral tribunal in order to found its jurisdiction, it is unlikely that it will be helpful to have any witness of fact evidence, including witness statements which may have been before the tribunal. And if the judge considers that witness of fact evidence is necessary, then he or she should give precise directions as to what the ambit of that witness evidence should be, having regard to the points of challenge which are raised. Fifthly, and finally, we say that the judge should also consider whether there's any need for expert evidence of any relevant foreign laws, and if the judge considers so, whether the most efficient path would be for the court to appoint a CPR Part 35.7 single joint expert. My lords, that concludes our submissions concerning rehearing, and I will now move to deal with the question of summary judgment, if I may. Having proposed a procedural approach to Article 5.1a challenges, which might help, we say, to ensure consistency of approach, I now turn to address the question of why we say the Court of Appeal erred in giving summary judgment and refusing recognition and enforcement of this foreign award. Now, here, my lords, the appellant's core submission is that it is questionable whether summary judgment should be available at all in a New York Convention challenge, because, as we know, an award debtor is entitled to a rehearing on challenge, but also we say reasonably that an award creditor holding a prima facie valid foreign award and having regard to Article 3 of the Convention must also be so entitled. So we suggest that given the prima facie valid nature of a foreign award, and in order to give effect to the Convention regime where very clearly we say, and this is as enacted at Section 103 of the 1996 Act within this jurisdiction, very clearly the burden of proof rests upon the challenging award debtor. And so the appellant submits that if summary judgment be available at all, and perhaps one should make, as I've said, no difference between the position of an award creditor and an award debtor. But it certainly shouldn't be available to an award debtor, because that has the effect of reversing the burden of proof. And there's authority for that proposition, my lords, in the case of Dardana. And that's at paragraph 32 in Dardana at bundle page 1495. My lords, we say that in respect of this case under consideration now, a peculiarity of this case is that the issue concerning summary judgment arose despite the fact that there was never any formal application to that effect in this case. Because what the procedural history of this case shows was that a challenge was entered, and that's bundle page 394, which incorporated an application for a trial of preliminary issues of law, which were actually, we say, issues heavily dependent upon fact. So they were, in other words, a wolf in sheep's clothing. So following the order made for enforcement ex parte by Mr. Justice Popperwell, as then he was, the award debtor applied for case management directions concerning the preliminary issues application. And Mr. Justice Tier based his definition of the preliminary issues put forward on the preliminary issues put forward, which by the award debtor. What he said in his judgment, which was very short at pages 318 and 319 of the bundle, Mr. Justice Tier said at paragraph 2, I've got two competing drafts. Considering the drafts in Schedule 1 to Mr. Dewan's skeleton argument, Issue 1 is there set out. It's rather fuller than Mr. Che's preliminary Issue 1, but Mr. Dewan's preliminary Issue 1 does not seem to me to identify what are the particular issues which arise on his challenge to the award. They concern the question whether there has been a novation of contract. Now, I pause there because, of course, that novation of contract allegation and preliminary issue had to do with the FDA, which stands clearly without the scope of Article 5.1a, where it's the question, where the question to be asked is the question concerning validity of an arbitration agreement, rather than permitting relitigation of findings of fact or an award by a tribunal concerning the merits of a case and the substantive contract. Mr. Justice Tier continued. So he said they concern the question whether there has been a novation of contract, whether the question of who is bound by the arbitration agreement follows the novation, or whether an arbitration agreement being separate from the main body has, as it were, a life and law of its own. Mr. Dewan's Issue 1, which sets out the two opposing arguments, seems to me to be appropriate. Now, despite the arguments which the appellant put to Mr. Justice Tier concerning what we said were the inappropriate nature of preliminary issues as a whole, a 1.5-day trial of those was ordered by the Commercial Court. And it was then, my lords, that the Wolf argument for summary judgment shed its sheep's clothing of preliminary issues during the trial before Sir Michael Burton. And he referred to it in his judgment at paragraphs 3, 64 and 65, subparagraph 4. And those are at bundle pages 334, 352 and 353. And during the hearing, because the learned judge felt dissatisfied with the preliminary issues as cast, he varied those preliminary issues during the hearing on the 29th of March 2019, and that's also apparent from his judgment. The Wolf argument then reappeared in the respondent's cross-appeal to the Court of Appeal, and the respondent argued that the judge below should have asked himself whether the award creditor of a New York Convention award satisfied what is in effect the summary judgment test, i.e. whether the award creditor had a reasonable prospect of successfully establishing a case for enforcement of the award under section 103(2). And that reference is to be found in the Court of Appeal's judgment at paragraph 61, and that's bundle page 282. The Court of Appeal then effectively gave summary judgment at paragraph 82 of their judgment. That's bundle page 287. Now, we say, my lords, that the starting point in any New York Convention claim within this jurisdiction is that a foreign award is prima facie valid, and for that we rely upon various authorities within the bundle. For example, Dalla at pages 1585 and 1599, but also the Supreme Court's decision in IPCO at bundle 2417, the UKOS and Dardana decision at bundle 1504, the Hulley decision at bundle 2533, and Dowans at bundle 2255. And so we say that the burden of proving that an award falls within a ground for challenge also clearly falls upon the party resisting enforcement, and so the challenger award debtor here. And again, there are various authorities in the bundle, many of them the same as I've just cited, which confirm that. There's Hulley at 2533, Dowans at 2255 to 56, Travis Cole at 2339, and also we say regard should be had to the UNCITRAL Secretariat Guide to the Convention at paragraph 43, which is at bundle 2032. My lords, we say that the reality is that if trials of preliminary issues or summary judgment is made available, it reverses the burden of proof. And we made this point before the Court of Appeal in our skeleton argument at paragraph 28, because on an application for summary judgment, it becomes the responsibility of the award creditor to place before the court whatever evidence it thinks necessary. And then sufficient evidence must be provided if the award creditor is to demonstrate that a trial is necessary. In short, my lords, we say that a summary judgment process against award creditors cannot have been intended by the convention. And it was plain, we say, from Sir Michael Burton's judgment at paragraphs 64 to 66. This is my Lord Legate.
How do you reconcile that with the fact that in the CPR, a defendant can apply for summary judgment? The burden of proof may be on the claimant, but it doesn't stop the defendant from seeking summary judgment if he can show that there's no real prospect that the claim will succeed.
My lord, it's impossible to reconcile it fully with the existing CPR. Our submission is that convention cases are particular cases. They are challenges where unusually there is an award pursuant to the convention which is brought into the country, a foreign award, and which is regarded as prima facie valid. And that is the reason why, if there is to be efficiency, we say that there could reasonably be consideration of a specific procedural regime for convention cases, with along the lines of the five-pronged procedural approach and proposition which I've outlined, and with a fast-track trial, but ensuring that, as Dalla stated at paragraph 104 when approving as of shipping, that all the documentary evidence that was available to the tribunal is before the trial judge for the challenge.
I don't see how you could put that much weight on section 102, because you do, it's true, have a prima facie valid award, but you've also got to produce an arbitration agreement. Of course, that is satisfied for these purposes by producing the contract made with a different party. But that just gets you across the line, as it were. It doesn't, under the authorities, Dalla and so forth, have any sort of positive weight when it comes to showing that the respondent is a party to that agreement.
Well, my lord,
proof may be on the respondent, but there's no sort of evidential burden carried by the arbitration agreement, because you can see on the face of it that the respondent isn't apparently a party to it.
My lord, what I said to that is that, of course, there was a very peculiar procedural turn of events in this case. And so if it is to be the case that summary judgment pursuant to the CPR is to be available in respect of convention cases and challenges, then we say that at least there must be the safeguard that there has to be a clear application in advance for summary judgment, as opposed to something which turns out to be a wolf in sheep's clothing, because the preliminary issues which were defined here by Mr. Justice Tier, who had scant reading time on a Friday afternoon with a very heavy list. Those preliminary issues are what we say was inappropriate, but then there is a further, we say, procedural defect in terms of rehearing, because those were effectively transformed, and as I said, the wolf shed the sheep's clothing of preliminary issues during a hearing, and the judge himself said that he was not satisfied with the preliminary issues and was uncomfortable. That was why he did not decide to give summary judgment, as he was encouraged to do. And that's clear from paragraph 64 to 66 of his judgment at pages 352 to 353 of the bundlement.
Well, if you're to get anywhere with that, you'll surely need to show us in what time's left, and I'll be quiet now, that there is something to argue about if there's going to be a trial.
My Lords, we also say that a useful authority on the question of reversal of burden of proof is the Dardana decision at paragraph 32, and that's Appeal Bundle page 1495. And in that case, there was an attempt to bring a challenge to the validity of the arbitration agreement, not under section 103 only, but within the ambit of section 102.1 of the 1996 Act. This is at page 1314 of the Appeal Bundle, that section. But the attempt was to place the onus of proof on the party seeking enforcement, so to reverse the burden in exactly the way we've been discussing in respect of potentially a summary judgment application. Now, that was rejected by the learned judge in the Dardana case in light of what he called at paragraph 32 the universally recognized purpose of the convention to assist with the enforcement of awards. We say that if applicable in respect of the test for summary judgment, then any test as to reasonable prospects of success of the appellant's convention claim would be met, because of course the prima facie, the foreign award, firstly, is prima facie valid, and two, there exist documents which demonstrate that there was clear conduct by the respondent in terms of performance, namely invoices, which were not before the Court of Appeal because they were not before the High Court on preliminary issues of law. So we do say that if permitted to be used by an award debtor in a challenge to a convention claim within this jurisdiction, that the summary judgment test would have the unfortunate effect of reversing the burden of proof. And that's contrary, we say, to the Article 3 obligation under the Convention of contracting states to treat foreign awards as binding. My Lord Sales.
I should confess to some difficulty in following the submission. I don't understand why you say that if one is applying for summary judgment, that reverses the burden of proof. I mean, surely the question of summary judgment has to be assessed, making due allowance for whatever burden of proof happens to lie wherever it lies. It's just a question then of saying, well, making due allowance for the burden of proof, is there something which needs to be argued about at the level of a trial of fact? Isn't that right?
Well, my Lord, the reality is if an award debtor applies for summary judgment, then it's the award creditor in defending that application which needs to demonstrate that it has a reasonable prospect of success. Now, is it enough to demonstrate a reasonable prospect of success in order to simply have a valid, a prima facie valid foreign award, which is, according to Article 3 of the Convention, to be treated as binding unless one of the grounds of challenge is proven and made out? What we say at the very least, even if summary judgment should be available and the burden of proof can be dealt with by the judge, is that there needs to be clarity in respect of the award creditor understanding what application it is facing, because ordering preliminary issues of law is very different to and facing a trial on preliminary issues of law is very different to facing an application for summary judgment.
But that seems to be a different argument. That seems to be an argument directed not so much to the availability in principle of summary judgment, but to say, well, if summary judgment is to be given, it has to be given in circumstances where there has been fairness in the procedure leading up to that.
Well, my lord, that certainly is our submission, that there must be fairness in the procedure leading up to it, because what one cannot have.
But everyone knows that.
Well, my lord,
they have to proceed fairly.
My lord, the courts may well understand that or know it, but we said the facts of this case show that there was an unfortunate procedural path, and that there shouldn't have been preliminary issues ordered at any point in time. None of the, or we say that the test for appropriateness of preliminary issues was not satisfied, and those submissions, well, those are clearly dealt with in our grounds of appeal, my lord, in relation to grounds 3 and 4.
Yes, thank you very much.
I'm grateful, my lord. My lords, I'm conscious of the time, and Lord Hodge, how long I may have left, because I need to address issue 3 very, very briefly indeed.
Well, Mr. Shea, you can eat into your reply time. I mean, sensibly, you must allow yourself some reply time in case new points are raised. But you have 3 minutes left of what you said yesterday you wish to allocate to this. If you wish to take another 5, it will come off your reply time.
My lord, I think that I would only require at the most 20 to 30 minutes in reply, if I may, and therefore it might assist if I'm able to take a little more time now.
Yes, well,
and be confined to 20 minutes or so in reply.
Yes, well, that will give you a further 10 minutes after 10 past 11, in order to reserve 20 minutes in reply. Thank you.
I'm grateful, my lord. We say that in relation to summary judgment, if that standard is to be available against an award creditor, or as between creditor and debtor in convention cases, then there are in any event compelling reasons why the issue should be disposed of at a trial in respect of this claim under the New York Convention. Now, if I might refer to one other reason for trial being appropriate, it might be that given by Merkin and Flannery at bundle pages 2698 to 2699, namely that given the convention rules and policy in favour of finality of awards, which was echoed by this court in Enker, the detailed findings of facts which have been made by an arbitral tribunal should not be easily reopened and substituted by the enforcing court with what Merkin and Flannery call little deference to the award. They suggest it's not permissible that the enforcing court or the party that was originally successful on jurisdiction be placed in a worse evidentiary position than the original tribunal if the former is to consider the question of jurisdiction afresh. That was a point we made before the Court of Appeal. What Merkin and Flannery say is that the consequence of this state of affairs is that where the challenge to the award is based on jurisdictional grounds, it's now indisputably the case under English law following the decision of the Supreme Court in Dalla that the party resisting enforcement has an almost unfettered right to a full rehearing of the issues put before the tribunal, provided it did not waive this right by appearing before the tribunal without objection to argue the jurisdictional point it seeks to raise on enforcement. This accords with the practice under Section 67 in respect of domestic awards, although that is an approach which we believe is not always appropriate. So we say that finally, in respect of summary judgment, that not permitting summary judgment procedures in convention challenge proceedings could also avoid asymmetry, whereby only the party resisting enforcement has, according to Merkin and Flannery, an almost unfettered right to a full rehearing of the issues put before the tribunal. My lords, I'll now briefly turn to the facts concerning the appellant's reasonable prospects of success and also the law in dealing with those. My lords, we say arguendo, and if the panel determines that English law applies to the arbitration agreement, that the appellant would still have reasonable prospects of success, and that is because of the factual evidence of performance which exists concerning the respondent in relation to the substantive contract, the FDA and the FOAs also within this case. And that would be enough, we say, to support a finding of preclusion under unidroit at the very least, as was found by the majority arbitral tribunal at paragraphs 203 to 206 of the award, and those are at bundle pages 461 to 463. Now that is because even if, which of course we dispute, that English law applies to the arbitration agreement, we say that the respondent misreads Rook advertising as rendering NOM clauses bulletproof to estoppel, firstly. Secondly, that if English law requires unequivocal words and conduct, but there is documentary evidence which was not before the courts below due to the particular course of procedural events with preliminary issues, and which demonstrates unequivocal performance of the FDA by the respondent, that there may be indeed unequivocal conduct by the respondent, which demonstrates that it did become a party or is stopped from contending that it did not become a party to either the FDA or indeed the relevant arbitration agreement. Thirdly, we say that in any event, the unidroit principles also apply here, and preclusion is available to the appellant pursuant to principles 1.7, 1.8 and 21.1.18, or I beg your pardon, 2.1.18, all of which were applied at paragraphs 203 to 206 of the award, which I've just mentioned. Now, concerning the facts, and very briefly, the appellant admits that the respondents engaged in clear and numerous acts of conduct in performance of the FDA and FOAs during the term of those agreements. It has also, we say, continued to operate without lawful license or permission from Kabab-Ji to do so, Kabab-Ji branded restaurants in Kuwait after the expiry of the FDA and tributary FOAs, and that has continued, we believe, until this day. Now, in our written case, at paragraphs 65 to 88, and those are at appeal bundle page 168 to 174, we gave examples of documentary evidence of this unequivocal conduct, my lords. But unfortunately, due to the summary nature of the hearings to date, which began with supposed preliminary issues of law, there are additional tribunals which were before the arbitral tribunal, but which were not before the first instance court and therefore not before the Court of Appeal below. Now, a very notable example of that is the invoices sent by Kabab-Ji to KFG, which were considered by the arbitral tribunal in their final award at paragraph 138, where they made what should be treated as final findings of fact. Now, that's at bundle page 443. And as we stated at paragraph 80 in our written case, and that, my lords, is at bundle page 172, what occurred was that Kabab-Ji invoiced KFG, and KFG paid Kabab-Ji directly franchise royalties and other dues which were owing and payable under the Franchise Development Agreement, the FDA, and the FOAs. Now, for the reasons explained at paragraph 81 of our written case at 173, the respondent failed to show that these payments were subsequently reimbursed by AHFC. And in any event, given that it was KFG and not AHFC which was invoiced, alleged internal payments from AHFC to KFG are irrelevant, we say. So we also say, my lords, that KFG, the respondent's assertion at paragraph 9C of its written case, that's page 207 of the bundle, that Kabab-Ji could point to no separate unequivocal representation by AHFC is moot where there is evidence, documentary evidence of these invoices, and also where it is clear that there are employees and officers of the respondent who were interlocutors of Kabab-Ji in day-to-day operations and contract negotiations, who wore two hats and were employed by KFG, but also potentially subsidiarily employees of AHFC, and that's at our written case at paragraph 69 in the bundle at page 169. Due to shortness of time, my lords, we rely upon paragraphs 49 to 62 of our written case in the appeal bundle in respect of the reasons why we say that if this court finds that English law applies to the arbitration agreement, but then of course applies the dual substantive laws or substantive applicable laws chosen by the parties to the agreement to the questions of fact, and those are of course English law and unidroit, that it is clear that the appellant has reasonable prospects of success. We submit that the majority arbitral tribunal was correct to follow the letter of the FDA and FOAs and to apply also the unidroit principles, paragraphs 203 to 206, to which I've referred you, and that those were correctly applied. We also finally rely upon the formulation of the particulars of our grounds at 3C, D, and E in the notice of appeal, which is at pages 55 to 56 of the appeal bundle. My lords, in respect of issue 3, as defined by the court, which is the question of whether there should have been an adjournment, that question is obviously to some extent now moot because the Paris Court of Appeal has already made its final decision in respect of the respondent's application to annul before the Court of the Seat, and that was on the 23rd of June of 2020, which we've discussed yesterday, and the Paris Court of Appeal rejected the annulment application and upheld the validity of the award. But in terms of principle, we say that it's very clear that Article 6 of the New York Convention provides a two-way street, and that while it may be far more commonplace for it to be an award debtor, for example, which is seeking to resist enforcement in a jurisdiction such as this, but is at the same time applying before the courts of a seat in a different third country, it may be more commonplace for an award debtor to be seeking an adjournment when also then perhaps the question of security might arise, which was discussed by this court in the case of IPCO not many years ago. It is nevertheless a two-way street, Article 6, and of course there is a power to grant an adjournment at the behest of the award creditor. We say that Sir Michael Burton correctly exercised his discretion in adjourning to await the Paris Court of Appeal judgment, and that there is clearly, as a result of what I discussed and described as being the general treaty reciprocity obligation under Article 3 of the New York Convention, that any enforcing court, while not having to, as we put in our written case at paragraphs 107 to 109, not having to look over its shoulder or genuflect to other courts, that the Article 3 obligation under the Convention does seem to suggest, and this has been the subject of numerous statements in English cases, that there should be some degree of deference or consideration shown to proceedings which are ongoing or which are, or indeed decisions of the Court of the Seat. My Lords, that concludes my submissions on the issues 1, 2 and 3 as defined by the court. My Lord Hodge, can I assist further?
I don't see anyone asking any questions. But that completes your submissions at this stage, does it?
It does, my Lord Hodge, and I would simply refer, obviously, to the parts of our written case which deal with that issue of adjournment, which is crystallised in the notice of appeal at ground 5, and that's on page 59 and 60 of the bundle, and dealt with in our written case at, I believe, paragraphs 189 and 190.
You can take it, Mr. Shea, that what is written in your written case will be taken into consideration by the court, as well as your oral submissions. So you need
My Lord, I'm most grateful.
Thank you very much. Mr. Diwan.
My Lords, can we start back at the beginning with issue 1, applicable law? I propose to deal with this in 2 issues. One is New York Convention Treaty Interpretation Point, which I will be brief on, and then contractual interpretation. Can we just take stock of where we are on Article 5.1a of the New York Convention? And essentially, the propositions are as follows. First, it is common ground now that Article 5.1a of the New York Convention, by its language, covers both express and implied choices of law to govern arbitration agreements. And that's by the use of the words subjected it and any indication thereon. ENCA, of course, provides support for those propositions, albeit, as Lord Legate said, one could argue that it's obiter there. The relevant paragraphs of ENCA are paragraphs 129, 250, 129 is where Lord Hamlin and Lord Legate made the point, but it's also in paragraph 251, which is Lord Burroughs, and paragraph 291, Lord Sales. Just by way of additional points on this.
Forgive my interrupting. There's a considerable echo on your voice, and I wonder if you could speak a bit closer to the microphone.
Of course, my lord, is that any better?
It is. It is. Thank you very much.
Apologies.
Not at all. I'm sorry to make the request.
Not at all. Just in terms of updated references for the court on this issue, obviously the court in ENCA referred to Bourne. Bourne has now issued a 3rd edition. Your lordships were referring to the 2nd edition in ENCA. So it's Vaughan, International Commercial Arbitration, 3rd edition, 2021. The relevant paragraphs are paragraph 26.05c, which is in the electronic bundle at page 2641. And he also makes the same point at paragraph 4.04, which is in the electronic bundle at page 1935. Now, the point I wanted to just draw your Lordship's attention to is the fact that the reason why, apart from the text of Article 5.1a, that he concludes that it covers implied choices, he notes that in those paragraphs that it is almost universally recognized across jurisdictions that implied choices, implied choice of law techniques are used. So that's one of his consistency points, consistent with the text of Article 5.1a. And I would also like to add one point which I made at first instance and was accepted by Sir Michael Burton, which is that when you contrast the language of Article 5.1a with the language of Article 5.1d, this is at page 1296 of the bundle, you'll see that the language of 5.1a is much broader. By using subjected it and failing any indication, contrast that with Article 5.1d, which talks about in the context of composition of the arbitral authority or arbitral procedure, it says was not in accordance with the agreement of the parties or failing such agreement. When you contrast subjected to an indication with agreement, that strongly indicates as a matter of text that you don't have to find it in the arbitration agreement and that you can derive it from the main agreement. Because otherwise you would have used similar language to Article 5.1d. Forgive me for treading over common ground, but I simply wanted to supplement the reasoning in ENCA by reference to those very brief submissions. Your Lordships may finally also want to note that in a document sometimes referred to as a historical treasure with respect to the New York Convention, which is the summary analysis of the record of negotiations of the New York Convention, which is to be found, which is a document of 1958, which is to be found in the electronic bundle at page 1329. Mr. Haight, who has done this analysis, he similarly concludes that the language covers tacit, what he describes as tacit agreement.
Mr. Diwan, could you give me the page number again, please?
Apologies, page 1329.
Thank you.
Now, the second point is to, which I believe is also common ground, relates to why one defaults to the rules of the forum for determining whether there is an express or implied choice of law for the purposes of Article 5.1a. In the same way that ENCA has established that that is the approach under Part 1 of the 1996 Act. And in my submission, the simple answer to that is that the New York Convention is deliberately silent on the issue. The obvious inference being that no attempt was made to adopt a uniform approach as to how to determine whether there is an express or implied choice. And that is hardly surprising because, as ENCA points out at paragraph 55, there is no uniform internationally accepted approach. We have the seat theory, which some jurisdictions have adopted, but as ENCA points out, many jurisdictions approach it from the perspective of the governing law of the main contract, as has been established by ENCA. Now, and just for your note, Vaughan similarly notes that there is a divergent approach across jurisdictions on this. Vaughan wasn't referenced in the relevant paragraph of ENCA, paragraph 55, so I'm just going to give you the page references, which is at page 1936 under heading C and page 1937 under heading D. My further point on this, which has been in my submission misunderstood by the applicant, is that the concept of defaulting to the rules of the forum, where an issue is not addressed by the New York Convention, is not an unusual technique of the New York Convention. That is my proposition. So in other words, on the question of capacity, which is also addressed by Article 5.1a, it is silent as to how you determine the personal law of a party, and therefore, as is well established by leading jurists, you default to the conflict of law rules of the forum. And that's what Vandenberg and Fouchard-Goldman have said. Vandenberg at pages, at pages 1824 and 1825 of the bundle, and Fouchard-Goldman at page 1840. My point is that, albeit we're not dealing with a conflict of laws issues, but how you determine a choice of law, the same logic applies if the New York Convention has not provided guidance. So where that leaves us, so far as the New York Convention is concerned, is that the position in ENCA at paragraphs 29 to 34, referring to the Supreme Court, the House of Lords case in Tunisia, we submit exactly the same approach applies under the New York Convention, which is that you apply English law to determine whether there's a choice of. And indeed, the logic of ENCA, which is that it would make no sense for there to be a mismatch between Part 1 and Part 3, so that you apply a different approach where, in respect of an arbitration seated in England and outside of England, that's ENCA at paragraph 135, we say that same logic applies in reverse under the New York Convention. Your Lordships may also want to note that the UNCITRAL model law, being the benchmark for international arbitral practice, does not contemplate a difference in approach on the issue of applicable law as between challenges at the seat and before the enforcing court. And that's Articles 34.2a1 and 36.1a1, which are drafted in identical terms and mirror Article 5.1a, and are to be found in the electronic bundle at pages 1358 and 1360. Now, the only remaining point on the New York Convention, which has emerged in oral submission, and I must admit I had not understood it from the written text, which is that as a matter of treaty there seems to be an issue which is emerged, which is as a matter of treaty interpretation of 5.1a, whether the law to which the parties have subjected the agreement can include principles of law. That seems to have emerged as an issue through my learned friend's submissions. Now, my primary submission on that is I cannot see how that can assist the appellant. It's the point Lord Sales put to the appellant, which is this. If assuming that for the purposes of an arbitration agreement under Article 5.1a, the reference to law is only to a system of law as opposed to principles of law, let's assume that's correct. What that means is that the English law clause of the FTA is effective for the purposes of Article 5.1a, and the reference to unidroit is ineffective so far as the arbitration agreement is concerned. It doesn't, which seems to be my learned friend's proposition, it doesn't invalidate the choice of English law. On any view, there is no principle on which one can come to that conclusion. Now, I hesitate to make submissions on whether the reference to law under Article 5.1a is broad enough to include principles of law, simply because I have not gone into it in any detail, because I haven't appreciated that that was the argument. All I can say is it's an open question by definition, because you apply, when one thinks of treaty interpretation, and this is in the bundle before your lordship, one applies broad principles of acceptance, bearing in mind that the language of a treaty is intended for a wide audience. So to use the words of the House of Lords in Fothergill and Monarch Airlines, 1981 appeal cases 251, the relevant passages at pages 2077 to 2078 of the electronic bundle, and then page 280. You talk about the international currency of the convention, and you therefore do not apply a statutory approach to interpretation. And that was, if your lordships may recall, was the Warsaw Convention case, another multilateral treaty, where the issue was whether damage included loss of contents to luggage, and therefore whether it needed to be reported in order to be able to make a claim under the Warsaw Convention. It was held that damage, even if as a matter of statute might only talk about the physical damage to the luggage, as a matter of a multilateral convention, you may interpret it as extending to the internal content. Now, and bearing that in mind, and principles of party autonomy, which are fundamental to the New York Convention, there would at least be the argument, it seems to me, that if you choose, for example, unidoir principles to govern the agreement, this agreement is governed by unidoir, the logic of ENCA might suggest that that would cover over into the arbitration agreement. But in my submission, it's a completely moot point before the court today, given that we're in a situation where we have a governing law clause providing for a national law. And the only question, in some ways, my learned friend's position assists me in my submission, because it means that you just disregard unidoir altogether for the purpose of the arbitration agreement and all the substantive issues arising on this appeal. Now, my lords, that is all I wanted to say on the New York Convention, unless I can assist further on the New York Convention points. So now I wanted to turn to contractual interpretation points, because where we end up on my submissions is that one is applying to the FDA the principles established by ENCA. That's where my case on the New York Convention leads one to. My lord, let me then, I'm conscious of time, but I have about 6 minutes, so I intend to proceed with contract interpretation points, if I may, before the adjournment. So, obviously I have summarized the principles in ENCA in my written case at paragraphs 25 to 35. And what I want to do is extract propositions and apply it to the FDA as I go along. My first proposition from ENCA is that where a contract contains a governing law clause, it is natural to interpret such a clause in the absence of good reason to the contrary as applying to the arbitration clause, because it is part of the contract and separability is generally not engaged for this purpose of construction. And the relevant paragraphs of ENCA for those propositions in my submission are paragraphs 41, 43, 52, 53, 60, 61, and paragraph 170 little 4. Now, the only 2 points of emphasis that I would place is that at paragraph 52 of ENCA, the Supreme Court did endorse, as I read it, the Court of Appeal's decision in Kabab-Ji. It made reference to it and treated it as being consistent with the approach that was being applied by the Supreme Court. That's my first point of emphasis. The second point is that, and forgive me for just repeating what will be obvious, but the Supreme Court rejected the Court of Appeal's approach at paragraph 60 of treating it when it said, and let me just get this up actually. So paragraph 60, which is at page 1739 of the title, what was specifically rejected there was what was the position of the Court of Appeal as to how you interpret the words disagreement. And what is stated here, reading from the fourth line, as we have discussed, a clause such as this agreement is to be governed by and construed in accordance with the laws of the main country is naturally and sensibly understood to mean that the law of that country should govern and determine the meaning and effect of all the clauses in the contract, rather than being limited. So I do rely upon that rejection for the purposes of our of the FDA in this case. Now, so turning to the FDA, in my submission, a complete answer to the governing law question is Article 15. Article 15 being found at page 379 of the bundle. This agreement shall be governed by and construed in accordance with the laws of England. This is, so applying the ordinary and natural interpretation, it extends to all the provisions, including the arbitration. Now, although not essential, Article 1, which is to be found at page 371, does reinforce that natural interpretation, but as I say, and as Enka has said, it's not essential. But Article 1 has defined the agreement, and this was not referred to, I believe, by my learned friend, and apologies if I've misunderstood that, but it defines the agreement as consisting of the foregoing paragraphs, the terms of the agreement set forth here and below. So it's defined it specifically as including all of the provisions, including Article 14. Now, my learned friend's contrary argument, and I'm just going to deal with this point before we take our break, if I may, is that Article 14.3 somehow displaces this natural construction. What I submit my learned friend is doing is to try and interpret the arbitration agreement in isolation from the remainder of the agreement, something which it would appear that is the approach that a French court takes and is inconsistent with Enka. So in my submission, Article 14.3 does not detract from Articles 1 and 15. And indeed, as the Court of Appeal held at paragraph 63 to 69, if anything, it serves to reinforce the choice of law, because the first sentence directs the arbitrators to apply the terms of the agreement. And therefore, one could say that's somewhat redundant. But I can see why it would do that in the context of the second sentence. So the first sentence directs the arbitrators to apply the terms of the agreement, hence including Article 15 and hence including English law. The second sentence directs the arbitrators, and I place some emphasis on the words also. So in addition to, and we can say also apply what we are calling unidroit. But that addition does not in any way detract from the obligation on the arbitrators to apply English law, which is the governing law in any event. Now, the reason why it seems to me that 14.3 has been set up in the way it has. It comes down to the point of the fourth sentence, which I have wrongly called the third sentence in my written submission, which is this. The fourth sentence, as we know, says, under no circumstances shall the arbitrator apply any rule that contradicts the strict wording of the agreement. As a matter of business common sense, I would submit that that sentence is directed at the second sentence, which is the addition created in Article 14.3 that does not exist anywhere else, and is saying, well, you're allowed to apply unidroit, but as long as you don't contradict the strict wording, i.e., you don't rewrite the agreement and you don't reinterpret it under principles contrary to English law. Because let me take that in my submission is the sensible of the fourth sentence. To take one example, unidroit articles 4.3 little a and little c, which is to be found in the electronic bundle at page 1426. They permit, under unidroit, for one to have regard to negotiating history and subsequent conduct for the purposes of interpretation. Now, that's obviously fundamentally contrary to English law, and it cannot have been intended, bearing in mind that fourth sentence, that you would have a disjointed mismatch as between English law and unidroit as to which principle to be applied. My learned friend's contrary submission, and this is where I was going to stop for the shorter journey, which is to say, well, since all of the terms of the agreement includes unidroit, therefore, when you're not allowed to contradict the strict wording, means you're not allowed to contradict either English law or unidroit. In my submission, that's an overly literal interpretation. And one then has to ask oneself the question, what was then the purpose of that fourth sentence? Because save for English law, the terms of the agreement and unidroit, what else is the arbitrator to apply? In other words, when looking at the rival interpretations, not as is well established, the court can look at which one leads to an interpretation that's consistent with business common sense. So at that point in time, my lords, I was planning to stop. Apologies for running over by a few minutes.
There's no need to apologise, Mr. Dewan. I merely asked you to select a convenient time at around 1:45. We will adjourn now for 5 minutes. All you need to do is mute your microphone and stop your video. Thank you very much. The court will now adjourn. We are now ready to resume, Mr. Dewan.
Apologies. My lords, a few further points on interpretation. I want to come back to paragraph 53 of ENCA, which is at page 1737 of the bundle. This court, paragraph 53, gave consideration to a number of principles which it held reinforced the general approach, which were certainty, consistency, complexity, artificiality, and coherence. Now, all of these points in my submission apply in the specific context of the FDA. But I want to place particular emphasis on two, which are consistency and artificiality. My points are these. As to consistency, on the Appellant's case, closely related issues, in fact, identical issues in terms of the factual analysis of this case, being the identity of the parties for the purposes of the contract and the arbitration agreement would be governed by different laws, leading to the potential for inconsistent results. What I have termed in my written case as the shipwrecked arbitration agreement scenario. You have an arbitration agreement that binds a third party without the main contract carrying over. And that is a real scenario on the facts of this case. The second point I wish to make is by reference to a point made by Lord Burrows, with whom Lord Sales agreed, at paragraph 238, which is page 1794 of the electronic proof bundle, which was made also on the consistency point, which is that if you split the laws between the main contract and the arbitration agreement, other problematic outcomes may occur, including differing effects on no oral modification clause. And of course, that again is a paramount issue in this case, because the no oral modification clauses of this contract are said not to apply to the arbitration agreement, even though by their terms they do. And that's because on the basis of a different legal system applying to the arbitration agreement. As to artificiality, the point made by this court is that it is not reasonable to expect commercial parties to treat a contract as including an ancillary or collateral contract. In other words, it's not reasonable to expect business parties to appreciate the nuances of separability. Now, in my submission, a fortiori, it is still less commercial reasonable to expect parties to understand or appreciate the French case law developed concept of autonomy, whereby the arbitration agreement is isolated from choices of national law. Just in passing, as to complexity, your lordships made reference to the possibility of amicable settlement provisions in arbitration agreements being dealt with by a different law, and thought that would create an unnecessary complexity, albeit it could be resolved, and the lordships did resolve it in that particular case. But it was nevertheless a proposition in support of having one entire law. Of course, there is an amicable settlement provision in Article 14. It's in Article 14.1. Moving on, the next proposition from Enker is that a choice of seat, and hence foreign curia law, is not sufficient to negate an inference that a choice of law to govern the contract was intended to apply to the arbitration agreement. And that's Enker at paragraph 170(5). And the rationale for that being, as set out at paragraph 69 of Enker, is that the curia law applies to the arbitral process and is conceptually distinct from the law governing the scope and validity of the arbitration agreement. So in my submission, the choice of a Paris seat in the FDA at Article 14.5 of itself is not sufficient to displace the natural ordinary interpretation of this agreement. Now, in Enker, the court identified two potential exceptions to the general rule. The first was depending on whether there was a provision of the curia law that indicates that the choice of seat is to be treated as a choice of law to govern the arbitration agreement in the absence of express agreement in the arbitration clause itself. And your lordships refer to the Karpatsky case Section 48 of the Swedish Arbitration Act and Section 6 of the Scottish Arbitration Act as examples of that. Now, of course, as was accepted by my learned friend, there is no such provision of the curial law, the French Civil Code being the curial law, in this case. And therefore, no case is being advanced to that gateway exception. Because this is, of course, an issue of French substantive law that we're dealing with, developed through jurisprudence, starting with the Dalico decision. The final point on this part of the case is the validation principle. And what your lordships held in Enker is that the putative invalidity, and this is at paragraph 97, is that the putative invalidity of an arbitration agreement may support the inference that it was intended to be governed by a law different to the rest of the contract, particularly having regard to separability and the fact that therefore the clause is more open to being separated from the remainder of the contract. Now, your lordships referred to two important authorities on this, which were the Hamlin and Talisker case at paragraph 100, and the Sud-America case in paragraph 103. Now, in my submission, this case has nothing to do with the application of the validation principle. My learned friend, in his written case, has said that the validation principle should be applied to ensure respect for party autonomy, uphold the validity of the arbitration agreement, and prevent a party from repudiating its consent to arbitration. And that was said in its written case at paragraphs 29, 128 to 129, and 173. And my learned friend specifically invoked Enker for those propositions. Now, in my submission, this fundamentally misapplies the validation principle. There is no issue in this case as to the validity of the arbitration agreement as between the identified parties and signatories to the FDA. A party cannot self-servingly invoke the validation principle to ignore its contractual bargain as to the circumstances in which a third party could become an additional party to that arbitration agreement. In my submission, that's anathema to the validation principle because it undermines rather than enhances party autonomy, which is the very purpose of the validation principle. What my learned friend's case is doing is starting from the premise that the respondent is a party to the arbitration agreement by reason of the award, which is of course subject to a complete rehearing, with this court not bound by any issue of fact or law, and relying upon the French court's decision, which has rejected the Paris Court of Appeals decision, which has rejected the annulment application. But that is precisely the issue in dispute, because the respondent is not, on the face of it, a party to the agreement, and the contract has mechanisms for the purpose of making a third party a party to the agreement. There's one additional point here that I wish to make, which is at paragraph 169 of my learned friend's written case, the invocation of the validation principle is premised on the acceptance that KFG, the respondent, did not become a party to the arbitration agreement under English law. It's specifically premised on that. Now, I do not see, therefore, how the appellant can even maintain its invocation of the validation principle without accepting that the respondent did not become a party to the arbitration agreement as a matter of English law. Because that's what is stated at paragraph 169 and has to be as the premise of the argument. My Lords, I've been relatively brief, but that's all I was going to say on issue 1. Unless I can assist you further, I was going to move on to issue 2.
I see no questions coming. Thank you very much, Mr. Diwan.
My Lord. This is the question of applying the summary judgment test in the context of a jurisdictional rehearing under the New York Convention. Now, the contention that is being advanced is that the appellant was entitled to a full rehearing. And what it means by that is a full trial of the jurisdictional issue, as opposed to what I would describe as an ordinary judicial determination. Now, in my submission, the appellant's case cannot be right for a number of reasons. First of all, and I think it will be helpful to have Dalla at page 1584 open. Or page 1584 of the electronic bundle. I'm also going to just remind your lordships of what Article 5.1a says, because this is a treaty interpretation point. So, Article 5.1 in the text, before we get to the sub-paragraphs, and that's at page 1296 of the bundle, forgive me for flipping between these two references. It says, recognition and enforcement of the award may be refused at the request of the party against whom it is imposed, only if that party furnishes to the competent authority, and then it gives the various proof that. Now, what Lord Mann said about that language in Dalla at paragraph 28 on page 1584 is that neither Article 5, and I'm reading from letter D, neither Article 5.1a nor Section 1032 hints at any restriction on the nature of the exercise open either to the person resisting enforcement or to the court asked to enforce an award when the validity of the supposed arbitration agreement is in issue. The onus may be on the person resisting recognition or enforcement, but the language enables such a person to do so by proving or furnishing proof of the non-existence of any arbitration. The language points strongly to ordinary judicial determination of the issue. And in my submission, there's a fundamental distinction between ordinary judicial determination and saying it has to be by way of full trial every time. So what I submit is that the text of Article 5.1a, supported by what Lord Mann said in Dalla, is to the effect that the court applies its ordinary CPR powers, having regard to the overriding objectives under the CPR, and it does not have its hands fettered or straitjacketed by some concept of a full rehearing. That makes no sense whatsoever. Indeed, Dalla is relied upon for the proposition that you're entitled to a full rehearing, and in my submission that represents a misunderstanding of the point in issue in Dalla. If your lordships go, and I'm sure your lordships have this fully in mind, and forgive me if I'm saying the obvious, but if we go to page 1581 and paragraph 21, your lordships may recall that the submission that was being made, which gave rise to this concept of a rehearing, was that the court should proceed by way of review. You'll see that Ms. Helbram's submission is at line 3 of paragraph 21. The court should proceed by way of review rather than rehearing. In other words, that you review the determinations of law and fact rather than rehear them. And it is in that context that the court rejected that proposition at paragraphs 26, 27, 28, and 160. And the reason why I rejected that is the obvious one, which is that it leads to an arbitrator being able to create its own jurisdiction by its own bootstrap. And that was the point made by Lord Saville at paragraph 160 at page 1622. Well, actually, we ought to start at paragraph 159, the last 3 lines from letter F. The point that is being made there by reference to the DAC report is that a tribunal cannot be the final arbiter of jurisdiction, but this would provide a classic case of pulling oneself up by one's own bootstraps. And for that reason, he goes on to say, in my judgment, therefore, the starting point cannot be a review of the decision of the arbitrators. No question of review arises at any stage. The starting point must be an independent investigation. The court was not saying that that independent investigation has to be by way of full trial. And as in my submission, that would make no sense at all. And I cited in my written case the first instance decision of Honeywell International Middle East against Maiden Group, 2014 2 Lloyd's Report 133, which is in the electronic bundle at page 2306. Now, that was an Article 5(1)(a) case, a jurisdiction case, and the argument being put forward there, and I use this as a classic illustration of why you need to have summary judgment powers and so on. The case there was that the contract was procured by bribery, and Mr. Justice Ramsey rejected that on a summary judgment basis under Article 5(1)(a) because no allegation was being made that the arbitration agreement itself was impugned by bribery, and therefore, because separability applied under the rules in question, it was a hopeless argument. So what's the point of having a full trial on bribery? And you'll see that at paragraphs 91, 92, and 93, which is at page 2318 of the electronic bundle. And I quoted in my written case paragraph 68, which I would invite the court to endorse, where he says the following. This is paragraph 68 at page 2317. In my judgment, the court should be cautious about taking, apologies, my lord, I'm going to take it from the full bundle because that's not a good quote. So what he says at paragraph 68 is, on an application to enforce an award, issues may arise, such as those which arose in Sovereigns, in which it is necessary for the court to decide an issue based on disclosure and cross-examination of evidence. However, in my judgment, the court should be cautious about taking that approach and generally be able to come to a decision on whether the grounds are made up without the necessity for holding a full hearing, but will be able to deal with them on the basis of the usual test on summary judgment. That is, whether there's a real prospect of successfully establishing the ground under section 103. And in my submission, that must be the correct approach, which is it always depends on the issue, the matter in issue, whether it requires more than a summary determination. Now, a suggestion was made, and I hadn't appreciated it went to issue 2, but it doesn't matter, that this defeats the burden of proof under the New York Convention. And in my submit, because the burden of proof rests on the award debtor to establish a ground under Article 5(1)(a). Now, I have to admit, I don't fully understand that as a proposition. And the reason is that the respondent has necessarily discharged its burden under Article 5(1)(a) by referring to the no, assuming we're in the position where we're dealing with, where we've got to English law, by pointing to the no oral modification clauses of the contract, pointing to Rock Advertising, the Supreme Court's decision that says it's binding, it is then, by definition, it has discharged its burden because there is no, and by pointing to the absence of a written document complying with the no oral modification clauses. When my learned friend, what my learned friend is saying, that is a estoppel case, the burden rests on the award debtor with respect to his estoppel case, and that's an evidential burden, which must necessarily fall on the award creditor when it is trying to respond to what is otherwise a complete defence under Article 518. In any event, I cannot, on the facts of this case, see how that would make any difference, given the legal impediments, which I'm going to come on to in the context of issue 3. My Lord.
It would be the right approach, wouldn't it, to, at least for the purpose of summary judgment, assume for that purpose that the correctness of the findings of fact made by the tribunal, and ask whether those are capable of disclosing as a matter of law an argument that the respondent became a partner.
I don't have any difficulty with that as a proposition, because the problem with my learned friend's case on estoppel is a legal one.
I appreciate that's your argument, but I'm just seeking to clarify what an appropriate approach is to the question.
My Lord, I accept that. In the normal way, in a summary judgment, well, it's not normal because we're dealing with an arbitration, and therefore one's starting from the premise that the factual findings are correct. And that I accept, my Lord, would be a correct approach. But there is nothing, we'll come on to it, but it makes no difference. Because one of the problems is that the tribunal majority didn't grapple with the no oral modification provisions of the contract. So on one view, their findings were directed, and don't forget, my Lord, their findings were whether their findings are relevant here, in circumstances where their findings were directed to a French law issue.
Well, they weren't entirely, because they treated the contract as governed by English law.
That's true, my Lord. Although they then modified the English law by reference to good faith.
Yeah. Well, they also didn't have the benefit of Rock Advertising, to be fair to them.
That's true, my Lord.
Thank you. Thank you.
Finally, there appears to have been a procedural complaint. But my Lord, can I just make one clarification, therefore, on the point, which is that, before I come on to this procedural point, which is that for the purpose of summary judgment, you would assume the facts, subject to whether a complete rehearing is required. But of course, to the extent that those facts haven't been decided or determined, or have been determined, or the issue, the relevant issue has not been grappled, there may be an issue as to what case is being advanced by the person resisting summary judgment. What I mean by that is, for example, before the tribunal, the appellant's primary case was one of novation. It then switched it to addition, adding a party, and its argument was that conduct in general was sufficient for it to become a party, for the respondent to become a party to the agreement. So the problem is that those findings on that conduct have very limited relevance to the issue of the effect of a no oral modification clause. Forgive me, my lord, I just wanted to add that one clarification, and I'll come back to that in issue 3. Now, there was a further final complaint on with respect to issue 2, which is in terms of procedural fairness, or a procedural complaint about the preliminary issue. Now, the difficulty I had with that, the same point was made to the Court of Appeal, but the as is recorded in Mr. Justice Sir Michael Burton's judgment, the revisions to the preliminary issues were revisions by consent. There was no complaint made about the preliminary issues, and so if we can go to Sir Michael Burton's judgment at page 335, paragraph 6. So Michael Burton reformulated the preliminary issues. You'll see that paragraph 6, and that was agreed. Now, what appears to be being said now is that these preliminary issues were never appropriate, but in my submission, it's far too late to make that kind of application on this appeal. That would have been a complaint to be raised at the time, and if there was if they nevertheless still disagreed, you would have had to challenge the order for preliminary issues. My lord, that's all I was going. My lords, that's all I was going to say on issue 2, and I was now going to go on to issue 3, which is the question of whether the Court of Appeal is right to refuse enforcement of the award by way of final determination rather than adjourn. Now, I just want to identify what are the sub-issues arising on this part of the case. As I understand it, there are 4. The first is the circumstances in which an estoppel can preclude reliance upon no oral modification provision. We submit, and I'll have to come back to this in a little bit more detail, that this has been addressed by this court in the MW Business Exchange against Rock Advertising case, following on, and this is quite important, from the earlier House of Lords decision in action strength, which I am also going to take your lordship to, because that's rather important on the fact of this case. And we submit that the appellant's case is bound to fail, as the Court of Appeal concluded, because it is seeking to apply in estoppel out of precisely the same conduct that is said to constitute the informal promise to vary the FDA, rather than by reference to a separate, further distinct conduct. That contention would destroy the function of a no oral modification clause as held in the Rock Advertising case. You have, and as held in the action, well, in the context of Section 4 of the Statute of Frauds case, in the action strength case, you have to identify separate conduct. And that's the important point. Now, so that's the first issue, which I'm going to come back to in some detail. The second issue is an issue of construction, which we have more or less addressed, but I will make some additional points. which is whether there is a dilution of the English law principles of estoppel applicable to a no oral modification clause by reason of the reference to unidoir principles in Article 14.3. As I say, I've made most of my submissions on that because in my submission, the short point is that you cannot rely upon unidoir to contradict English law under the scheme of this agreement, and therefore unidoir does not dilute English law principles of estoppel. The third point is whether there was any error of principle in the application of the summary judgment test to the facts of this case on the basis of potentially further evidence coming to light. This is what Lord Justice Flo referred to as the Mr. McCullough point. The fourth point issues is whether nevertheless the court was wrong in the exercise of its discretion under Article 6 not to adjourn. That, it seems to me, as my learned friend appears to have accepted, is moot, given that the Paris court has rendered a decision. The only basis on which you could revisit the adjournment in my submission would be if you were to decide that French law applied, so that there was an issue of principle which went wrong in the context of the adjournment question. But I'll come on to that because my learned friend tries to rely upon the French court decision by reference to the Min Metals case and this concept of giving weight to decisions of the supervisory court. And that's a misapplication of principle, as I'm going to come on to. So those are the four issues that I intend to address you on in the context of issue 3. My lords, first of all, therefore, the no oral modification provisions and estoppel under English law. Now, I wasn't going to take them up, but the relevant provisions of the contract are Articles 19, 24, and 26 of the FTA, which is pages 380 to 381. And they require a written document signed by both parties to the FDA for any amendment. In addition, I do draw your attention also to Article 17, which requires a written document signed by both parties for any waiver of the requirements of writing. Now, the first point I make by reference to rock advertising, which is to be the relevant bit, is to be found at page 1701. The first point I wish to make is that my learned friend has made reference in his written case to Globe Motors, paragraph 54 of his written case, the Court of Appeal decision in Globe Motors, for estoppel principles. Sorry, the effect of no oral modification clauses and estoppel. Now, that case was specifically overruled at paragraphs 9 and 10 of rock advertising. So you'll see in paragraph 9 at page 1701 at just between letters B and C, reference to the view expressed in Globe Motors on no oral modification clauses, and that you should be able to vary them by way of an agreement. And you'll and of course, Rock Advertising declined to follow that approach. So the first point is that my learned friend's reliance upon Globe Motors is not good in law. Now, going back to Rock Advertising, I rely quite heavily on paragraph 12, which is where the court, Lord Sumption, provided the rationale for the enforcement of no oral modification clauses. And I'm picking up from just above letter H. And His Lordship gave 3 reasons. The first is it prevents attempts to undermine written agreement by informal means, a possibility which is open to abuse, for example, raising defences for summary judgment. And in my submission, that's another reason, going back to issue 2, as to why it should be open to dispose of issues like estoppel by way of summary judgment, if they can be, because it would undermine the no oral modification clause. Secondly, in circumstances where oral discussions can easily give rise to misunderstanding and cross purposes, it avoids disputes not just about whether a variation is intended, but also about its exact terms. Thirdly, a measure of formality in recording variations makes it easier for corporations to use internal rules. So that was the rationale for giving effect to no oral modification. And then the important point for our purposes and in the context of the facts of this case is paragraph 16 at page 1704 to 1705 from letter H, where it says, the courts below rightly held that the minimal steps taken by Rock Advertising were not enough to support any estoppel defences. I would merely point out that the scope of estoppel cannot be so broad as to destroy the whole advantage of certainty for which the parties stipulated when they agreed upon terms, including the oral modification clause. At the very least, there would have to be some words of conduct unequivocally representing that the variation is valid, notwithstanding its informality. And something more would be required for this purpose in the informal promise itself. And that's the bit I rely on, and its reference to action strength, because this is a case where my learned friend is relying upon the conduct said to go to the informal promise as being the conduct said to go to the estoppel. So, in other words, he is completely destroying the effect of the no oral modification clause. And I do want to take your lordships very briefly to action strength, which is at page 1519. Page 1519. Just to remind your lordships of the facts of that case, that was a case of an alleged oral guarantee, contrary to section 4 of the Statute of Frauds, whereby the owner of land orally guaranteed to pay a subcontractor if the contractor didn't pay the subcontractor, and then it reneged on the promise. And the promise was held to be because it was not in writing, it was contrary to section 4. The court nevertheless went on to consider circumstances in which an estoppel precluding reliance upon section 4 of the Statute of Frauds could bite. And the relevant paragraphs for our purposes are first at page 1525, paragraph 9, and the reference there to Lord Bingham's speech, where he says, its difficulty, in my view, insuperable, arises with the second question. For in seeking to show inducement or encouragement, action strength can rely on nothing beyond the oral agreement, which in the absence of writing is rendered unenforceable. There was no representation that it would honour the agreement despite the absence of writing, or that it was not or that it was not a contract of guarantee, or that it would confirm the agreement in writing. So in other words, what is being said is you need more than the promise itself. If we go on to paragraph 35, at page 1530, and this is from Lord Clyde's speech, and again, reading from the second sentence, the only assurance given to action strength was the promise itself. In order to be stopped from invoking the statute, there must be something more, such as some additional encouragement, inducement, or assurance. In addition to the promise, there must be some influence exerted by Saint-Gobain on action strength to lead it to assume that the promise would be honoured. But there is no suggestion made that Saint-Gobain said or did anything to lead action strength to assume that Saint-Gobain would not stand on its rights. And then another important passage at paragraph 53 on page 1535 of Lord Walker's speech, which is to treat the very same facts as creating as an unenforceable oral contract and as amounting to a representation that the contract would be enforceable despite section 4, and to do so while disavowing any reliance on the doctrine of part conformity would be to subvert the whole force of the section. And all of these speeches point to the same point, which has been summarized by Lord Sumption and Rockout, is that you have to be able to delineate between the conduct said to go to the promise and the conduct said to give rise to the estoppel. So just to take a few simplistic scenarios, you could have an oral promise followed by an oral representation that you will not rely upon the no oral modification clauses, and we don't have to really concern ourselves with whether it's a promissory estoppel or a representation of fact. It could be either. It could be a promise not to invoke the no oral modification clause, which would be a promissory estoppel, as in a future, a promise for the future, or it could be that this contract, this agreement is valid, notwithstanding we haven't complied with the no oral modification clauses. So it could be a representation, so to speak, of fact or law. But the point is, it's separate conduct. Now, and that, of course, is consistent with what Lord Briggs, albeit dissenting in Rock Advertising, said, which was that at paragraph 24, page 1706, which is that on the facts, there couldn't possibly be a variation because there was no promise with respect to the no oral modification clause. So either way, it's consistent. The second scenario is where you have, and this is where the difficulties arise for my learned friend, is where you're saying that conduct gives rise to an informal promise. If you want to do that, then you have to delineate and identify conduct which is said to give rise to the informal promise, and separate conduct which is said to give rise to the estoppel. And as I will come to, that's why the Court of Appeal said at paragraphs 80 to 81, well, you need something more than the conduct said to give rise to the informal promise, and you're not pointing to anything. I'll deal with the invoice point which my learned friend raises in a moment when I apply these principles to the facts. But in my submission, that is the legal principle relating to where the space in which an estoppel can operate in the context of an oral modification. Now, so that's the first issue. What is the English law of estoppel so far as an oral modification? The second issue is whether Unidroit and its reference in Article 14.3 dilutes the estoppel principle. Now, I have already provided my my submissions on the construction of Article 14.3 and in particular the fourth sentence. And that was the position which the Court of Appeal accepted at paragraph 76, my Lord.
What scope on your analysis is there for the unidroit principles? I mean, one could always say that if they produce a different result from English law, there's a contradiction, and so English law predominates. But obviously, the parties intended that they should have some application.
Is your Lordship asking, putting to me, what application did unidroit have in this case? No,
could it potentially have on your analysis of the clause 14.3? So, for example, give us an example of when it would make a difference to the analysis for the arbitrators.
Well, my Lord,
it isn't cancelled out on your interpretation of the last sentence.
Well, my Lord, I haven't. Forgive me if this is a failing on my part, but I haven't gone through the entire 1,500 pages of unidroit or thereabouts to identify points that it addresses which are not addressed by English law, to identify areas where it could fulfill a gap-filling role, which is a role contemplated by unidroit. So I can identify obvious inconsistencies between English law and unidroit, but I haven't conducted the process of identifying where it would have a gap-filling.
Well, why might it not, for example, allow reference to pre-contractual negotiations in construing the contract? I don't see why that involves contradicting the strict wording of the agreement. Obviously, you couldn't rely on the negotiations to contradict the agreement, but you might rely on them to interpret it.
Well, it depends on how you interpret the strict wording of the agreement. Bearing in mind that the strict wording of the agreement includes Article 15.
Well, that's why I'm looking for some interpretation that doesn't cancel out unidroit, which your interpretation seems to do completely.
Well, my Lord, I can't answer that question precisely. I'm not sure it does cancel it out, because insofar there's no inconsistency, then it could be relied upon.
But what do we mean by inconsistency? Because if it would lead to a different result from that which English law would otherwise arise at, on one view there's an inconsistency, and therefore
yes, my Lord.
It doesn't add, it can never add anything, if that's what you mean by inconsistency.
Well, I do say that, the Court of Appeal accepted that. I do say if it's going to give rise to an inconsistent interpretation of the terms, for example, if you, under English law, you interpret a particular provision as meaning X, and unidroit would treat it as Y by reference to material which English law would treat as inadmissible, then in my submission it's contradicting one of the terms of the agreement, which is that the agreement should be governed by English law. I'm not sure how you can marry up English law and unidroit principles which are inconsistent with English law.
So in effect, it has no relevance at all. It can never produce a different result from the result you would have come to without it.
Well, but my Lord, it just depends. I mean, different systems of law, whether on the facts of this case it is redundant, doesn't mean it didn't have an aspirational purpose. Different systems of law have dealt with are in different states of development. And for example, it may be that there are issues in UNIDROIT which have simply not been addressed by you. In that situation, it wouldn't be inconsistent. And also, one of the things which the preamble, preamble 6 makes reference to, of UNIDROIT, page 1393, is where the law is in a state of development, i.e. it's not settled. Where the law is in a state of development and is not settled, then it seems to me there would be no inconsistency. So page 1393, it says, in applying a particular domestic law, courts and arbitral tribunals may be faced with doubts as to the proper solution to be adopted on the law, either because different alternatives are available or because there seems to be no specific solution. My lord, so that would be my submission on that, which is where things are not clear or settled, then UNIDROIT could be, and it talks about it being used as a source of inspiration in those circumstances. My lord.
Yes, I'm not sure that that works terribly well, because where the law is not settled in advance of a court determination, what we're envisaging is that you're before the court and the court has to determine it, which it will do according to its own criteria of resolving areas of uncertainty in that legal system. So I'm not sure that an English court could refer to UNIDROIT and say we're going to change the law of contract in some way, or apply it in a different way from how we would otherwise have done. But I wondered whether UNIDROIT might add something so far as the good faith and fair dealing provisions are concerned. I don't know what you would say about that. For instance, if the contract had areas of discretion, so that a party on the face of the contract could, I don't know if this is true of anything in the contract, but could on the face of the contract have a choice as to how to behave, whether there would be scope for supplementation by reference to UNIDROIT, if you like, to superimpose on that discretion certain obligations derived from UNIDROIT as to how the discretion would be exercised.
Well, my lord, that as a proposition I have no difficulty, because in the sense that that would not be inconsistent with English law in supplementing it in that way. There is, of course, a good faith provision in the contract as well, Article 2, but it wouldn't be inconsistent with that to identify other areas where good faith derived from UNIDROIT could be applied.
But are there any? We're looking for assistance as to whether there is any practical content.
May I suggest this? There's obviously the lunchtime adjournment coming up. Maybe I can park that for the moment, rather than wasting the court's time. We'll come back to that after the adjournment. Yeah,
well, certainly so far as I'm concerned, that sounds sensible.
Yes, there's no difficulty with that, Mr. Dewan. I think you're running ahead of schedule, so that's not a problem at all.
I'm grateful. My lord, the next point after dealing with unit one was the question of my learned friend places reliance on Article 2 of the FDA, which is the good faith clause, as potentially diluting the estoppel requirements of the English law. Now, Article 2, which is at page 371 of the bundle, requires the parties to act in accordance with good faith and fair dealing. In other words, in performing their obligations, they have to act in good faith. Now, in my submission, a good faith performance obligation and a good faith interpretation principle cannot dilute the requirements of a no oral modification clause, because a no oral modification clause means what it says, and good faith is not a principle to dilute clear language, first of all. And secondly, it can have no relevance to the space in which an estoppel operates, because it would otherwise defeat the very purpose of the no oral modification clauses, which the parties have bargained for. So in other words, when one talks about good faith, and when one talks about good faith, one talks about adhering to the spirit of the contract, observing reasonable commercial standards of fair dealing. There is no want of good faith in requiring parties to comply with their contractual bargain. And neither is there any want of good faith in my submission as a matter of interpretation in saying that an estoppel can only operate in the space left open by the existence of the no oral modification clause, which the parties have bargained. If authority is needed for any of these propositions, in my submission, these are basic first principles. But on questions of interpretation, obviously good faith doesn't modify clear language. And your lordship, Lord Leggett, in the Yan Seng case, at paragraph 139, this is page 1664 of the electronic bundle, made the point that a good faith interpretation, or giving a reasonable interpretation which promotes the values and purposes expressed, is essentially part of the English law principles of interpretation in any event. So you can't use good faith to dilute the no oral modification clauses themselves, because they have a very clear and specific purpose. And the only other proposition, as I say, is that what does good faith performance mean? We have English case law which has dealt with what good faith performance is, and I made reference to this in my written submissions. There's the Court of Appeal decision in Mid-Essex Hospital Services against Compass Group at paragraphs 110 to 112, which is page 2296 of the electronic bundle. And what was said by the Court of Appeal there is that good faith performance obligation imposes a requirement of honesty in performance, adhering to the spirit of the contract and observing reasonable commercial standards. There is nothing inconsistent with that in applying estoppel only in its appropriate space, as I would put it. My lord, that's all I was going to say on good faith and the assertion that that somehow is to be treated as diluting estoppel. My lord.
Yes, so maybe I've misunderstood what you're saying, but I'd have thought that potentially there's a simpler way of you addressing that point, because Article 2 is part of the contract itself, and what's being sought to be relied upon here is an estoppel to prevent KFG denying that it's a party to the contract. So it's almost a bootstraps argument again, isn't it? That where what is an issue is whether KFG is a party to the contract. You can't begin by saying they're bound in some way by an obligation under Article 2 of the contract, which affects the usual standards that would be applied. And I would have thought that the significance of the no oral modification provisions in the contract itself are really as a signal on which affects third parties as well, as to what would be required to make someone a party to the contract. And so, well, anyway, I'm just struggling to see why you need to put it in what seemed to me a slightly complicated way.
My lord, I accept that. I have difficulties with the argument, and I'm perhaps creating a man of store that I don't need to, but I'm having difficulty with the argument because by definition, a good faith performance obligation applies to performance of the contract, to which by definition KFG is not a party.
Right.
So I'm having difficulty to understand in what space it operates in the context of an estoppel argument that precludes KFG from relying on the no oral modification clauses. I'm having difficulty in understanding how the good faith performance in any way has any relevance to the question in issue.
Yes, well, it may be that you were in effect putting what I was putting to you, and I just have misunderstood it, so forgive me.
No, my lord, I'm sure it's my own clarity. My lord, it's 1 minute to 1. I was going to go on to something else, and I thought maybe that's great.
Well, as I said, I think, Mr. Dewan, you are getting well through your submissions as it is, so that there is no problem adjourning a minute early. The court will adjourn, and we will resume again at 2 o'clock. Thank you very much.